Like Abbakyari, hip-hop leader Nnamdi is also entitled to legal advice. Lawyer Ejimako writes Attorney General Malami. Welcome to the news and please subscribe to our channel. Ejimako, in an open letter to the Attorney General of the Federation and Minister of Justice, Abubakar Malami, said the update from the AGF office requesting further proof of some suspects of Kyari's investigation had created a new legal connection with Kanu. Aloy Ejimako, special counsel to Nnamdi, leader of the indigenous people of Biafra, has said there is a legal connection between embattled Deputy Commissioner of Police, Abbakyari, and the Biafra agitator. Ejimako, in an open letter to the Attorney General and Minister of Justice, Abubakar Malami, said the update from the AGF's office requesting further proof of some suspects of some aspects of Kyari's investigation had created a new legal connection with Kanu. The lawyer argued that if the AGF could offer legal advice in the extradition process of Kyari, then Nnamdi is equally entitled to any legal advice that impacts his prosecution. He wrote on 13th March 2022, it was widely reported in the media that the Office of the Attorney General of the Federation cancelled a legal opinion advice exonerating DCP Abbakyari from the allegation of money laundering, which formed the main basis from which the United States of America is seeking Kyari's extradition to America. One of such publications in a well-respected national daily was captioned, "Hush Pipi, new legal advice from AGF's office exonerates Abbakyari of money laundering allegation." Inasmuch as this legal advice does not sit well with certain segments of Nigerians and even the Americans that seek the extradition of Abbakyari, it needs to be stated that the rendering of legal opinion or advice comports with the constitutional powers of the Attorney General of the Federation as preserved under the Constitution of the Federal Republic of Nigeria. Suffice it to say that this very legal advice exonerating Abbakyari has created a new legal connection with Abbakyari and Mazi Nnamdi. The connection lies simply in the fact that if Abbakyari is deemed entitled to such legal advice that will surely impact his extradition, Nnamdi is equally entitled to any legal advice that impacts his prosecution. In other words, the pertinent provision of the Nigerian Constitution and Nigeria's Extradition Act must be applied equally to all. Thus, Nnamdi is now entitled to a same legal advice, which must include the following. 1. Under the universal doctrine of speciality, which pertains to extraditions, an extradited fugitive, whether renditioned or otherwise, is subject to prosecution only for those offences for which he or she was surrendered, extradited or renditioned. Nigeria recognized this doctrine under Section 15 of Nigeria's Extradition Act, which provides that fugitive surrendered to Nigeria is not triable for any previous crimes. Where, in accordance with the law of any country within the Commonwealth, any person accused of an offence committed within the jurisdiction of Nigeria is surrendered to Nigeria by the country in question, then, so long as he has not had a reasonable opportunity of returning to that country, that person shall not be detained, whether under this act or otherwise, tried or otherwise dealt with in Nigeria, for in respect of an offence committed by him before he surrendered to Nigeria, other than the offence for which he was surrendered to, or any lesser offence which may be proved by the fact on which his surrender was granted. Or B. Any other offence being one corresponding to an offence described in Section 20 of this Act of the same nature as the offence of which he was surrendered, provided that a person falling within this section shall not be detained or tried for an offence by virtue of paragraph B of this section without the prior consent of a country surrendering him. 2. To be sure, the foregoing provisions were as regards Nnamdi breached in all the material particulars. First, as of 19 June 2021, when Nnamdi was abducted in Kenya, he was facing 4-count charge, none of which included or bordered on terrorism. Today, the charges have been expanded to 15 counts that included and bordered on terrorism. Unarguably, this is a clear violation of the doctrine of specialty, especially in view of the provision that a person falling within the section, that is Section 15 of Nigeria Extradition Act, shall not be detained or tried for any new offense without the prior consent of the country surrounding him. In this very instance of Nnamdi Kanu, the surrendering country is Kenya, and there is no evidence that a consent was obtained before this new 15-count charges were brought. 3. Conversely, the same doctrine of specialty is also recognized in the Kenyan Extradition Act, which as Section 6.3 states that a fugitive shall not be surrendered or committed to, kept in custody for the purposes of surrender, unless provision is made by the law of the requesting country or by an arrangement made with that country for securing that he will not, unless he has been restored or had an opportunity of returning to Kenya, be dealt with in that country for or in respect of any offense committed before his surrender, other than A, the offense in the respect of which a surrender is requested, or B, any lesser offense proved by the facts before the court of committal, or C, any other extradition offense in respect of which the Attorney General may consent to his being so dealt with. Unarguably, these provisions have extra territorial application to Nigeria because as regards Nnamdi Kanu, Nigeria, the requesting country, which fact has been affirmed by the sheer compelled presence of Nnamdi Kanu in Nigeria. Interestingly, Nigeria also strictly requires the self-same doctrine of specialty to be respected when it comes to fugitives extradited from Nigeria to other countries. Section 3.7 of the Nigeria's Extradition Act states that a fugitive criminal shall not be surrendered to any country unless the Attorney General of Nigeria is satisfied that he will not be detained or tried in that country for any offense committed before his surrender other than the extradition offense. In view of the foregoing, it has become necessary for the Honorable Attorney General to revisit the matter of these new 15 court charges presently standing against Nnamdi Kanu with a view of urgently issuing a legal advice to the effect that all things new charges will be withdrawn forthwith. Failure to do so will amount to a clear violation of the doctrine of specialty as enshrined in Nigeria's Extradition Act and equal protection of a law as preserved in the Nigerian Constitution. At the end of all this big drama, I just hope that everything will work out fine. They won't listen to you, to your lawyer, but soon Elohim will speak in the language they will understand. How do you want Aboki to understand the law? Quarter System Attorney General. Okay, on this note, we've come to the end of the news. We'll say thank you for tuning in to listen. Until I come your way next time, enjoy the rest of your day.